everyone. Thank you for joining us. Really looking forward to the conversation. If you haven't listened to my podcast episode with Dan, it dropped, is it last week? Yeah, it was just last week.
Yeah.
So this is like a double dose of Dan, but I mean, once you hear him today, you're going to know why, we drop these in subsequent order. So I'm really looking forward to the conversation. Dan, do you want to do a quick, kind of couple seconds on yourself as well too, before we kind of jump in and talk about, some of the privacy laws that came into effect and what we should think about in selling?
Certainly. Yeah, I'm Dan Frechtling and delighted to be with you again. Thanks so much, Jake, for allowing me to be a guest here. And small doses, I think, is about all you can take from me. So thank you for that. I'm CEO of Boltive. We stop invasive media on the web. It includes security and privacy, primarily protecting the web, keeping it safer. But we work with brands so that they keep their users safe.
Yeah. Yeah. And Dan's story, again, if you want to hear the whole story, it's a really inspirational one. And I think, really truly building a purpose-driven company, which I think that there's a lot of people that talk about that, purpose or mission-driven, but, truly what you're doing at Boltive, I think is a definition of that, you could say, of doing it. So Dan, I'm looking forward to the conversation, and we'll just kind of jump in here. So for a lot of you who may be listening, you might have saw this topic and you're like, privacy laws, yay, can't wait. Like, this is going to be, a scorcher. The reality is, and I think it's because, Dan, like in the US, right? Like, we've taken the attitude a little bit like privacy laws, like, yeah, sure. Yeah, whatever, right? Like privacy laws, like, yeah. We can still cookie people and we can still do all this stuff, especially on the B2B side, right? Which is, B2B is actually, there've been carve outs, as you well know, in a lot of these laws around B2B to say, actually, like this is applicable to like, the B2C marketing, but not as much to the B2B. And so what privacy laws, maybe if we want to start there, Dan, talk a little bit about the privacy laws that went live on the 1st and why people should care and how, maybe how this is different, because I'll tell you, I missed the boat in 2018 on GDPR. I was convinced. I was like, GDPR will signal to the US, and here we are in 2023 and we're just getting state laws. So I know I am not a great predictor here. So tell me why this year and these laws that went to effect are different.
Sure. Yeah. Well, I think pundits are usually wrong, and certainly my predictions are probably more wrong than most. But we can look backward and talk about what has happened to get us to this point with some certainty about what actually happened. Privacy regulations are really unlike any regulations we've ever seen before in history. And you think back on the history of regulations, they began in 1887 with the ICC to regulate railroads. And that was the first time that regulations targeted a specific industry. And then since then, we have more regulations than we'd like to count. For FCC for telephone, the NRC for nuclear, FERC for electricity, FAA for airplanes, et cetera, et cetera. But as these typical regulations happen, they go country by country over time. And they tend to be sector specific. What we're experiencing with privacy is no industry has ever, you can say this more clearly, no group of industries has ever had to change so quickly on a global basis. And that's what we're experiencing. GDPR, you mentioned, in 2018 was a big was a big milestone, and that's essentially affected everything else. But there's other parts of the world that have gotten ahead of the US, like the LGPD in Brazil, even China with their PIPL, and other countries last year were particularly active. Japan amending its regulations, Australia, India, Canada. But the US 2023 is the big year. And already, as you mentioned a few days ago, January 1st, California and Virginia new laws took effect. And we have Colorado and Connecticut laws taking effect July 1 and Utah December 30. What does this mean? What do these laws that just took effect mean? Well, they mean a lot of things, but I think a couple things for B2B marketers is that, and anybody really in advertising or marketing, under California's new CPRA amendment, there is this concept of a 30-day cure that used to be true. If you were warned by California, you would have 30 days to solve whatever infraction they were alleging you had been guilty of.
Yep.
And that is going away. That has gone away if to the extent that enforcement's happening. And for Virginia, which is considered to be more of a business-friendly law, it actually has a term that's even more strict than California, which is that you need to opt in. You need to get opt-in consent from consumers if you're going to share their sensitive information. And all the California aspects and most laws in the US operate under an opt-out system, meaning that if you don't say anything, you don't declare anything,
right,
the presumption is you've opted in. And this is now different for sensitive information, which includes things like ethnicity, immigration status, union membership, health conditions, religion.
What about things like email, phone, cell phone number? Do you think? I mean, again, we're not lawyers here. Big disclaimer. I should have put this up here. We are not lawyers. Okay. Yeah. Dan and I talked about this last week. But in the past, has email and phone number been included in some of that?
Yes, those. So what the winds have changed a little bit. Yes, email, phone number, address. That's considered sort of personally identifiable information,
right?
And that is sensitive. But what's different about sensitive information is sort of changing the mindset from we're not just worried about data breaches anymore. We're actually more worried about data sharing and data abuse, right? And that is when people's interests, their demographics, their personal beliefs, when that gets shared, because that's very lucrative for online advertising and marketing and e-commerce, when that gets shared, that's also betraying privacy, not just the contact information that used to be considered just personally identifiable information. But we have,
you see it, and in B2B, Dan, I think that this is what we're talking about. There's a whole slew of, providers out there that do different forms of retargeting, right? That aren't just like, to your point, they're not just like kind of basic data points. They are using, their AI or their version of machine learning is using different aspects like this, most likely in their algorithms.
Yeah.
To target people.
Yeah, and that is true. Yeah, algorithms are part of where the regulations are going. Ironically, California has not finalized its rules on automated decision making. That should happen shortly. But that's where we talk about things like profiling. And profiling is when you make decisions that are from derived data. And derived data is also considered protected. So if you take the informational aspects that we talked about, and then you interpret something, if someone was, for example, if their location suggested they were near a mosque or in a mosque, that they might be practicing that religion, then that is derived data that is also protected. But the aspects of these algorithms and the automation are going to be under scrutiny too.
Do you feel for a lot of people, so right now, if you're a B2B company, what are the big things, again, like we talked about this carve out that's changed, right? And it specifically said in CPRA that it did change. Like, what do you think as a B2B organization, you should be kind of like, what's the first step, right? Like, again, if it's no longer immune, like what are some of the implications, like standards, do's and don'ts, coming up here is Data Privacy Week as well too. So what do you feel like for a lot of B2B marketers or sales leaders or sales teams are like the more important implications?
Yeah, well, let's first talk about what you're referring to, Jake, when you talk about the B2B exemption changing, because what happened in California is that the privacy laws CCPA was focused on consumer data, and that exemption for B2B contexts expired on January 1, which means that your clients, your prospects, even employees and job applicants are under this jurisdiction, and you're subject to compliance requirements in the CCPA. So what does that mean? You need to disclose the information you're collecting and how you intend to use it in your privacy policy. And if you don't do that, that creates risk of enforcement action. You also need to adhere to the rules that apply to consumers, which is allowing subjects to view, edit, delete the information that was collected about them, right? So that creates some additional work too. And California, I believe, is the only state with a general privacy law that applies to these personal details for B2B. So we've talked about Virginia and Utah and Colorado and Connecticut. And the general belief is that these other states recognized how hard it is to apply these laws to B2B, because selling and marketing in a B2B context is different. Like a great example is signing a contract, right? That with that signature is PI, personal information.
Interesting.
So if someone says, go and delete that, how are you going to delete delete a signature from a contract? So there's some wrinkles in there that haven't been quite worked out.
Right. Yeah, they signed a contract with another company, then you start spamming them in the future, and they're like, delete my personal information.
Right.
How do I'll tell you another, Dan, I'll tell you a scary use case. I'm actually nervous for a lot of B2B companies is, a lot of these new forecasting prediction models, what they do is they pull in information from the salesperson's email, which includes their contacted, like the interactions they're having with customers, both the calendar invites, anything shared in a calendar invite. They're pulling into the algorithm email back and forth. They're pulling in sentiment of that to then help to better predict forecast. And I don't think, and there's these tools like they're called Clary. There's a whole bunch of them. I don't think they know how to exclude data, and so I think that will be the scary part, I think, Dan, for some of these like predictive companies that are used to just kind of sucking in data behind the scenes and saying, hey, you know what, for this deal, you can include these 5 people, but this person has chose to opt out of having any of their information collected from us.
Yeah.
Dan, I don't know how they're going to do it. I got to be honest. Like that to me is, I think, one of the scarier pieces is that I think a lot of these tools were built without the idea of individuals being able to opt out of their information being used in any capacity versus opting out from, marketing communications, which has been around.
That's a good point. There's another example of that, which is you think of pixels and beacons that are placed on web pages. And those are very common. They've been common for years, and they've always operated without the fear of infringing on privacy. Well, under the laws in California, that changed. So let's take an example.
Yeah.
So Sephora got in trouble allegedly and settled because there were analytics. There's an analytics pixel on its web pages that was sharing data about user behavior, but the way that it was being shared, it was being commingled with information from other users, and that crossed the line. Well, there's lots and lots of analytics pixels, and this has raised questions about, well, Sephora settled for $1.2 million, and one of the big allegations was that they had this pixel that was sharing analytics data. What about all the other analytics pixels that are out there? And what you're describing is you can have a single pixel, you can have a beacon on a web page. It's doing more than one thing. It might be doing something very positive, which is frequency capping and making sure that an individual doesn't see the same ad too many times and get annoyed. Yeah. But if that pixel's doing something else, and it does this other thing, because as long as we're there, we might as well run some more analytics, share some more information, right? Now you have to offer an opt-out right. So if that consumer opts out, then they opt out of the frequency capping, and so their experience gets worse too. So it does create some unintended consequences in the service of trying to be more privacy protective.
Interesting. Yeah, it's interesting. And I look, you've talked a little bit about this, and I think for those of you, because we're talking about this pixel, and we can talk about cookies as well. Let's maybe take a step back. Like for a lot of people, they might be hearing about some of this, like, I kind of get it. Talk a little bit about, because you and I talk about it on the podcast. If you want to hear Dan talk a lot more about it, you can check out the podcast. But talk about the cookie. Talk about like maybe a little, just like a quick kind of like history lesson on the cookie and kind of like what got us here today.
I think the cookie history is fascinating, and the thing to recognize, and you mentioned this earlier, Jake, is that privacy was a non-event until something like 15 years ago, particularly in the US. And now we have this thing called Data Privacy Week, which is January 24th to 28th. And how did we get to this point, right? How did it get from a non-event to a week-long commemoration? Well, it's really the origin of tracking, and cookies are a big part of that. So if we become web archaeologists for a moment, you think back on how you used to browse for cars. In the dawn of the internet, you used to visit auto pages like Yahoo and MSN and AOL, right? And car makers put ads on those destinations. It was very much like the magazine model. But by 2002, you had search engines led by Google that became the starting point for web surfers. And what that did was it took this audience that used to go to a few places and just fragmented them, shattered and fragmented them. And so advertisers had to work with ad networks and ad tech to aggregate all these places that people were going to get their information on cars. And that's kind of where the cookie, the demand where the cookie came from. But the origin of the cookie prior to that was something completely innocuous. In 1994, it was a unique ID at Netscape. There's a 23-year-old engineer who all he wanted to do was to anonymously and privately remember visitors in the Netscape Navigator. Right. Because prior to that point, the web would forget if you signed in and what your preferred language was.
To help. It was to help, right? To just to help. Hey, this will probably make things a little bit easier for users.
Yeah, that was intended, right? And it was called the cookie. And when people think of cookies, they think of chocolate chip cookies. In this case, it was called the cookie to refer to the fortune cookie, because there was the concept was there's a unique ID inside that cookie, right? That would be a fortune. But then the cookie became a monster. And you had, after 1994, right, it took about a year for DoubleClick to realize that these user cookies could be used to follow people all over the web, back to people who were buying cars. You could see how many auto intender sites they went to. And because DoubleClick was so pervasive and in so many places, they could see that. And that was the beginning of all these targeting innovations over 20 years that have actually helped sales and marketing to quite a degree. Interest-based ads, knowing what kind of interest categories people were in, so you serve them something relevant.
Right.
In 2007, we had the iPhone launched. That took that same model and into cross-app advertising, which was the mobile app equivalent of interest-based advertising, which is tracking people across non-affiliated apps. And then it kind of metastasized, got bigger and bigger. In 2014, you had these massive device graphs that were connecting mobile and desktop, later connected TV. And that's where we started to reach this culmination point where you had that going on, and you had several incidents that started with Edward Snowden and then went to Yahoo and Equifax and Cambridge Analytica, and all these pivotal events that got people aware of privacy problems. And the cookie became a target at that point, which I think it was the great collision of 2018 when GDPR was passed.
That's right. That's actually a good kind of segue. So we've got this kind of collision, this thing again that was intended, and just like any good thing, marketers or sales take anything with good intentions and use them until they either burn out or something else needs to be developed. Obviously now let's talk about Meta, right? And it's B2C, but there are a lot of B2B implications. Meta is no longer able to use behavioral advertising in Europe, which I don't think people quite, again, I just think in the US, and maybe you can talk a little bit about the difference, like the big differences you see between the, Europe and UK, little slightly tweaks on every law in the US, but this is a big deal. Again, like you talked about, being able to break down the information a pixel creates, and just how the US, I just feel like, is not prepared for this level of specificity. Talk a little bit about like what's going on with Meta and some of the changes or new ideas that this brings about of things that could come to the US.
Yeah, there's a prediction that what we're seeing with the laws in California, Colorado, Connecticut, Virginia, Utah, and the greater activism of GDPR enforcers. In this case, it was the Irish Data Protection Authority, that we're going to see advertising and marketing as a regulated industry by the end of 2023. That is, and it's going to be done so globally. But Meta was a particular case. What Meta was doing was that Meta had claimed permission from users, or I should say, they had claimed the right to be able to share users' data for advertising, because in their terms of service, there was a term in there that users were allowing Meta to do so, and that Meta
at the bottom of page 82, probably.
Yeah, and Meta
section 3.
Right, which was very clever, right? Meta said, well, that's a contract. They've accepted the terms of service. In the terms of service, we're allowed to use their data to serve them relevant ads and other content to make their experience better, because they accepted that. And that, I think that change in terms of service occurred in 2018 when GDPR was live. And so that the so-called contract meant that Facebook and Instagram could share personal data without users actually consenting to that. And in return, the users got personalized online ads. And Meta argued, well, that's just simply part of the service that we offer, and we contractually owe people that. Well, I think it was the European Data Protection Board that drew the hard line here. And then the Irish Data Protection Authority, the DPC, followed that and told Meta that they had 3 months to comply with this ruling that you could not use contracts. You actually have to get user consent. Now, Meta is fighting this. They're appealing this, but probably not going to prevail in that, in my opinion. So what this means is that users would have the choice of whether or not they want their data used for targeted promotions. And remember what happened with the iPhone when app tracking transparency appeared, and you were allowed to select if you wanted an app to share your location or not. Well, most people said no. So this could cut off one of the most valuable parts, really the most valuable part of Meta's business. And so we're probably, for that reason, we're probably going to see a long legal fight as a result of that.
And that'll affect, I mean, correct me if I'm wrong, it won't just affect probably Meta, it'll affect any of these companies that set up shop in Ireland, right? Like a LinkedIn maybe, right? Any of those companies that do business, are technically headquartered, right? And a lot of people did because of taxes and other reasons. It'll affect those organizations too. And there's a lot, right? People don't realize how many of these companies are headquartered in Dublin in particular.
Yeah, and so there was some that accused the Irish DPC of taking kind of a kid glove approach to regulating those companies, yeah. And it's responding and essentially saying with these latest fines that it's not. Many companies do, yes, social networks that follow a similar model where they're relying on legitimate interest, is what it's called when contracts are used, are likely going to have to change and get individual consent. And this is a good thing for privacy, but it's not necessarily a great thing for everybody, because there's a lot of small businesses that rely on ad money and rely on traffic from the ads that they place on Facebook for their livelihood. So there's this trickle down effect that could undercut small businesses and the traffic that those ads generate for restaurants, retailers, barbershops, et cetera.
Yeah, or having to find different new ways. Again, it's like we kind of leap forward, leap back, and hopefully we'll come up. It's kind of like a lot of things, right? You go too heavy one way, then you overregulate, and then you kind of find this, like, I call it like this kind of like happy medium. So, all right. So I think a lot of people listening, help them to understand maybe some of the nuances between Europe and the US, meaning like and obviously there's a lot in terms of like some of the privacy laws. Like, what are the big things that you think, Europe is doing X, US is here, but US might get there again? You said, kind of by end of 2023 is, potentially.
Yeah, I think Europe is about 2 years ahead of the US, I would say. And it's GDPR, it's a PECR, Privacy and Electronic Communication Regulation. And these are the sorts of things that would, in a B2B context, restrict cold calls and cold emails. So if you are in business and you're contacting EU citizens, it's not where your business is based, it's where the prospects are based, then you're already covered. And the process you use to collect data must be GDPR compliant, and you need to source data with security measures in place, especially if you're getting data from a third party or an external source. You're also going to need consent, and opt-in consent under GDPR, which is different than the US. The US is more of an opt-out, meaning, as I said a moment ago, the presumption is that you're consenting to this until you say you don't.
Right.
So what do? You think, starting point, you need to have a clear and accessible privacy policy. For California law, you need new links for do not sell my personal information or do not share my personal information. But you need to walk the talk also. It needs to go beyond what's just on the website. You need to be able to honor opt-outs and make sure your third parties are honoring those as well, which is a lot harder than it sounds.
Oh, I can imagine. And I guess the thing I read about CPRA, you can tell me, is it that unlike GDPR, which is like what you said, whether if you're based there or if you're doing, you are present or kind of emailing into there, you're all subject. CPRA is focused on employees that are based in California. Is that right? Versus like, or is it also focused whether you're based in California or you're also interacting with, you're doing cold outbound to California?
It's if you do business in California, then you're subject to it. And it's the same thing for Virginia, Colorado, and Connecticut. If you do business in California, you collect personal information, therefore, in California. And there's also another threshold, which is $25 million in annual revenue.
Correct.
So now that doesn't mean if you make less than than 25 million, you don't need to worry about this because there's consumer trust issues and
Sure.
that sort of thing. But they're really concerned above that revenue threshold. Are you doing business and collecting a PI in California? And are you sharing, selling, or buying personal information for 100,000 individuals per year? Or if more than half of your revenue is from selling and sharing personal information.
Ooh. Yeah, there's gonna be some companies like in our like Zoom Info and some others I think that are gonna have a interesting time. Maybe I should reach back out to them and see how they're handling this as well.
Yeah, any company that gets qualified as a data broker needs to register, and there's some specific sensitivities around that.
Oh, I can imagine. All right, Dan, this has been amazing. I got to tell you, I think for a lot of people out there, we've been immune or like lackadaisical maybe about this for a long time, where it's we just haven't had to think about it as much. And I think for the first time, there's a little bit of teeth to some of these. And again, as you're seeing the state, almost anything, once the states get a groundswell enough, that the federal government will most likely step in with some type of overarching, potentially to just eliminate the confusion. What are maybe just as we wrap up here, maybe a couple of kind of final thoughts from you on, if you're a B2B company, maybe the top one or two things that you would do right now?
Mm-hmm. Well, we're coming up on Data Privacy Week, but I think one thing to keep in mind that's a pretty short ceremony. The other 51 weeks of the year are also the regulators are going to be looking at you. But I think assigning a data protection authority doesn't have to be an officer like in Europe, but having someone who's name in the frame and responsible for that. The other real basics are mapping out where your data is. What you do, an inventory of where you're storing data, and do a flow map of where those data flows are going. Mm-hmm. And it's often that those third parties that become the more complicated aspects, is because you're sharing data with an email provider, or you're sharing data with a marketing agency, right? And that can be personal information that falls under the jurisdiction here. So I think those were other things I would speak to. Look for software. We're early in the market, so consulting is a common way to solve problems. Sure. But there's also software like Boltives and others that automates this for you. So look to do that. It's similar to other regulations that we had to deal with, like CAN-SPAM in 2004, Sarbanes-Oxley. You in the beginning, it becomes some investment, but the annual refreshes become much easier, especially with software.
Yeah. Then again, as you said, there's more and more software. It's a company called Data Grail that I know out of San Francisco that does some of this as well across your kind of marketing automation, your sales engagement platforms, et cetera. So I think we'll see a lot more. So Dan, look, I really appreciate it, man. This is a great conversation as usual. Make sure to follow Dan on social media. Go check out what he's doing at Boltive as well too. If you're, in the business and you're trying to figure some of this out. Dan and his company, obviously this is a big part of the world that they come from and that they help organizations with. And definitely check out the full episode on the podcast. It's just jakedunlapshow.com, and you can hear a lot more about Dan's story and more about the history of the cookie as well too, which I obviously find pretty fascinating as well too. Because I think most people think it's like cookie crumbs, right? It was like crumbs, but it's a fortune cookie.
It is crumbling. It is crumbling.
Well, it is now for sure. So Dan, I appreciate you. Thank you everyone for joining us, and we will see you next week. Thanks everyone.